one, isn't it? There's always one. So let's rock off. Have you? I don't know if any of you saw the news at lunchtime, but Doug Myers has died.
He's been fighting cancer.
He has, but exactly what we've been talking about. He is survived by his wife Barbara and 3 children from an earlier marriage. Watch this space.
That was a nasty breakup when it happened.
Watch this space. It's exactly what we deal with these days. That was a really weird situation, wasn't it? Wasn't a will that was on Robert Chambers' computer, unprinted and unsigned. Wasn't that probated? It's validated under Section 14 of the Wills Act.
Was it? I thought they had a will that they thought through and done and,
It was on the well, I might be maligning it, but from my recollection, my understanding was it was on the will, on the computer, and didn't get much further than that. But that was validated. Because somehow they were able to satisfy themselves that it was an indication of what he wanted. I don't think it was a good move for the profession.
Do they like seek evidence that he created the document and things like that?
Presumably.
That it was final, not draft. Still not working.
Yeah, it was dodgy.
Must have had to have other extra.
Yeah.
I think lawyers couldn't write, I mean, under our code of conduct, are we not supposed to, what is it, Chris, you know them back to front, you're not allowed to be able to write your own will? Or can you write your own will but not for your family? You can't do it for your family, right?
I got a will at the moment which I'm trying to get validated in Section 14 where a guy handwrote a will and left everything to his mates. But he'd written a will in 1977 when he was a boy going overseas because he was told he has to do a will. So he did a will then leaving things to his parents. Well, his father died before him. His brother committed suicide before him with no kids. His mother was in a home. When they told the mother he died, she died 3 hours later. And her will gave it to him and his brother. So we got this big cycle going.
A cycle of mutual intestacies.
Yeah. Public trust are acting for the mother whose estate's insolvent. And so the judge is going, well, what's going to happen on intestacy of the mother? And go, public trust don't want to look into it because it's insolvent. And so we came back and forwards. We'll only look into it if the will's not validated and we're going to get something.
Yeah.
I've got a note written by a chap in hospital, an old chap, and it's and I actually think it will get validated. The judge has come back and said he wants a bit more information, but he hasn't said no. So and it's even though it's poor English, poor handwriting, it's
Meets none of the rules for a will. Doesn't meet any execution requirements. Unclear as to what its intentions are. Unclear to its meaning, but it will be validated. Yeah. Social world. Let's roll on, shall we? Okay, we dealt with beneficiaries. We're doing fixed and discretionary trusts. Where would there be a fixed trust? And because we're trying to get out of here earlier, I'm going to answer the questions for you. In a will, it's a fixed trust, isn't it? Because it describes who gets what, when and where. The features being it fixes the entitlement for beneficiaries, and that's always the challenge we have with clients. Do you understand that when you die, your children get what it says under the will at the time of your death? That crystallises their entitlement, as opposed to the discretionary trust where we get a bit of flexibility to work out when best to provide for them. Obviously, the features, there might be contingency, so I leave all to my children, or if either one of them dies, leaving children surviving them, then those children will inherit. And then you could get the question of whether you want to put an age in there. If you do put an age in there, you've got to be aware of your perpetuity periods. So I leave everything to such of my children as shall survive me, or if any of them shall not survive me, but leaving a child or children, him, her, or them surviving, who was achieved at the age of 25 years, which is what often they put. That could be a bit of an issue because obviously the perpetuity period is a life in being plus 21 years. It's the old common law rule. And if the child wasn't born at the time of the deceased's death, you're going to have a breach of perpetuity rule. The next is 25 years. So again, something to think about in those circumstances. Do you think in a perpetuity period for a trust deed you can say a life in being plus 20 years or 80 years under the Perpetuities Act, whichever comes first? I don't think you can, because you have to specify what the perpetuity period is. And you either say it is a life in being plus 21 years, or it is the perpetuity period up to 80 years under the Perpetuities Act. To say either one of them, I think, creates uncertainty, and it's taking the best of both worlds. Well, why would you choose both? Yeah. I think I think it's a dangerous drafting technique. In any event, there are going to be very few cases where we have perpetuity issues because they usually get wound up well and truly beforehand. But it's just asking for trouble. I saw that recently. I thought, well. Can't hurt. It would bring us in line with a lot of the international jurisdictions, which are going to either 100, 120, 150 years. It's old 1964. If we're reviewing the Trustee Act from 56, why wouldn't we review the Perpetuity Act from 64? It's all a bit of a muchness because there aren't many trusts these days that last a full length anyway. So it seems to be a cosmetic thing, and I don't think it's going to have a significant amount of impact on what we do. So I'm rocking along. Powers of appointment. All right, we've touched on this earlier, so I'm not going to have to spend a lot of time on this. Yay, team. We know what it is. It's the power to make allocations of income or capital. Here's your technical question. Do we know the difference between a general, special, and a hybrid power of appointment? Again, rhetorical questions. A general power of appointment is where the person who has the power is unfettered in that he or she can give the property to anyone in the world, including themselves. If that's the case, what sort of a power of appointment do we have under a trust deed? Well, it's not going to be general because there are limitations as to who, so it's going to be a special power of appointment or a bit of a hybrid, isn't it? But we know it's not going to be a general power of appointment. Again, technical issues, when you get down to issues of trust law and succession and equity and those sorts of things, there's often talk about the powers, whether they're hybrid, specials, generals. That's why. Okay, here's a question for you. The trustee shall have the power to appoint the trust fund and the income thereof upon such trust for the benefit of any one or more of the discretionary beneficiaries at such ages or times, and generally in such manner as the trustee may determine. Special? Certainly not general, is it? It's probably a bit of a hybrid because there are, we know it's certainly not general because there are certain people he has to give it to, but there are bounds there and no fixed aspects within the certain parameters. You're probably going to get through your career without ever having to do any dissertation on whether a power is a hybrid, a special or a general. And if that's good, all power to you. Great. Income and capital distributions. I think this is the epitome of what we want with trust, isn't it? That the trust is the ability to turn on or turn off the flow of assets. And that's where it comes to income and capital. This is the sort of clause that you'll probably have seen or use in your trust deeds. And this is bearing in mind, as I said, I separate mine between income and capital. This is not exactly my clause. I don't give away all my trade secrets, but this is a general clause during the trust period. So, okay, well, that's important to understand. There's a time frame here. Obviously, the trust period expires on the vesting day, but during the trust period, the trustee may pay, apply or appropriate all or any part of the net income. So that net income will obviously mean there'll be a definition somewhere defining what net income is, after paying charges, costs, expenses, things like that. 2, or for the maintenance, comfort, education, advancement in life, or other benefit of any kind. That's the important general one, to make sure we can get the funds out to the beneficiaries. of one or more discretionary beneficiaries with power to exclude any others of them, so we can select which one we want it to go to in such manner, and if more than one of such shares as the trustees, and proportion as the trustees think fit. Very common sort of clause because it covers all the bases. And there's nothing wrong with that clause. Next part is the accumulation, that during the trust period the trustees may accumulate all or any of the net part of the net income of the trust fund and add it to the capital of the trust fund. What's the period for that we use in trustees these days for accumulating? There's a tax-based reason, isn't it? Old trustees say that if it's not accumulated within 6 months, it's not paid out within 6 months, it's deemed to be accumulated, added to the trustee and trustee income. But the tax rules changed 3 or 4 years ago and they extended that time period to 12 months because essentially what happens in the accounting world is most people with trusts have got accountants. You're on their agency list, which means you're a year behind with your accounting. And if you want to make distributions of income, you had to do it within 6 months. That never happened because the accountants never got around to doing it. Usually 12 months is a better time frame. And technically now it means that you can make either income distributions from beneficiary income or capitalised as trustee income, and it sort of reconciles more with the Trust Act. So it sort of remedies something that was honoured in the breach. Capital is quite similar provisions. During the trust period, the trustee may at any time pay, apply, appropriate or transfer the whole or any part of the capital, so we can pick and choose different parts of the capital. 2 or for the maintenance, comfort, education, advancement in life or other benefit of the beneficiaries, with power to exclude any others of them in such manner, and if more than one in such shares and proportions, in subject to such terms and conditions as the trustees think fit. Again, a very general and commonly accepted clause which meets most clients' requirements because they want to make sure that they can be favoured above anybody else. So with both the income and the capital, you can say to your client that the trustees can exercise their discretion in your favour and don't have to give out anything to the other beneficiaries who are your children, depending on needs, circumstances, but in the general scheme of things, this is what clients want to make the trust work for them. Resettlements, I love these. Now you had a stir fry for lunch, didn't you? Yeah. It highlights, we're taking part out and putting it into somewhere else. It's a physical change. It's not a little cut and paste job. It's a resettlement. And we discussed some of the concepts of that. And this is an example of a resettlement clause you'll find in an ordinary trustee these days. The powers of the trustees in relation to income and capital contained in clause 4 and 6. Clauses 4 and 6. Clause 4 was the ability for distribute income. Clause 6 was the ability to distribute capital. So the powers shall, without limiting or restricting those powers, include the power at any time or times during the trust period to resettle by deed the whole or any part of the income or capital of the trust fund upon trust in any manner which, in the opinion of the trustees, is for the benefit of any person or object who or which shall for the time being be a discretionary beneficiary, provided such resettlement does not transgress the rule against perpetuities. So that's a fairly general one. It doesn't say you can include in the resettling trust other people, so there'll be a question as to whether that would work in that situation. Right, so if this is a resettlement from a parent's trust to a child, and the child's trust is for him and his wife, would it fall within that power? Probably would, because one of the discretionary beneficiaries is a beneficiary of the new trust, so it would work. So the issue would there be the advice you're giving to the resettling trustees and the receiving trustees that you're actually benefiting somebody who was not a beneficiary of the original trust, although the power is within the scope contemplated by the resettlement clause in the trust deed. And that's often what we get with trustee clauses, is that there is power to do something. It's a question of whether it should be done. It's the appropriate thing. I'll come to that again shortly. The main thing there, obviously, we're all aware, is that the perpetuity periods can't be breached, which often means that the trust period for the receiving trust has to be brought forward to align with that of the disposing trust, provided there's power there should be power in the new trust deed to bring forward those dates. And then that brings us to the rule against perpetuities was with the vesting and maximum duration. So the common law rule. Do you ever see any trust deeds these days with the lives in being? I saw one about a month ago which had the royal lives in being in it. Old trust deed, it wasn't new. Which was, the last surviving heir of King whatever it was. Very hard to trace that one down. Well, it's easy to say it's 80 years from the date of this trust deed. And interestingly, although it's simple to say, the perpetuity period applicable to this trust will be 80 years from the date of this trust deed, is it from the date of this trust deed? Does that mean it's from, so if it's settled today, 80 years from today's date, does that start tomorrow? Or does it start on the day it's settled, from and including the date of this trust deed? I've seen it where it's 80 years after the date of this trust deed, and I think, bang, they've missed it by a day, because that takes it out the 80 years. I normally say 80 years less 1 or 2 days from the date, from and including the date of the trust deed, to make sure we fall within. Again, perpetuity periods, I'm not aware of any cases that I can recall where it's been an issue, because most trusts don't last that long and we have the wait and see rule. But again, it's nice to get the drafting right. That's our Perpetuities Act there, where we can specify any other period. But interestingly, I think you have to use those specific words, and the perpetuity period applicable to the trust is such and such. You can't just refer generically to it, you've got to use those specifying words. And again, I've seen trusts without that, but I don't think it's a major issue. Oh, here we go, look. Perpetuity period means the period that commences on the date of this deed and ends 80 years, less 1 day after the date of this deed. So that's bringing you within, so you're covering off there. So the specification of the perpetuity period is not enough. The trust fund must vest within that period. So you need to have a vesting day. So there's no use just specifying what your perpetuity period is. You have to have an event that occurs within that time frame, which is it vests on the vesting day. And there's an example of a clause you might see. A vesting day definition means the first occur of the expiry of the perpetuity period, or the trustee is appointing an earlier day. What you might need to do drafting these days, because there is talk of the perpetuity periods being extended, it may be that you add a further option to that, and it might be or such other day as the governing law applicable to this trust permits. Because if you've got an ability to transfer the trust to another jurisdiction, and they have a 150-year perpetuity period, you want to make sure you can amend the trust deed to deal with that. So having something that allows you, or such other day as is permitted by statute, something like that, will cover you for any extension that will arise. Okay. Do you guys go for unanimous or majority decisions? Unanimous? Unanimous? Oh, you're perpetual. You're monopoly decisions, aren't you? You're unanimous, unanimous, unanimous. Have you come across situations where there've been majority? Okay. Why do you choose unanimous? Because you can select majority, can't you? My theory, and I'm a unanimous person, my concern is that in most circumstances, most of the trusts in existence, the mum, dad plus independent trustee, if you have majority decisions, the real risk is that the independent trustee will just be overridden time and time again. Mum and dad will do what they want. And whilst that's bad from a decision-making proposition, it also means that the independent trustee who might not agree with the exercise of power or discretion will be bound by that decision, because if mum and dad as trustees exercising their majority power decide to buy a commercial building with a 95% loan, the bank will require all trustees to sign, which means that the dissenting trustee will have to sign and be liable. And although they will obviously look for a limitation of liability clause, they are caught up in a transaction with which they don't agree. So for that reason alone, I would say never go for a majority decision, always unanimous. And if they can't agree with that one, you don't want to be a trustee of that trust, because what's the point in having the independent trustee. Historically, trustees had a duty to act unanimously, and I think that historic position is becoming more entrenched in everyday practice. There are, of course, trust lawyers out there who don't promulgate the theory of independent trustees at all, and that's, again, a question for another day. I'm not a believer in that. I think there should be an independent trustee. And if there is independent, I think you should have your decision part of the process. I'm getting ahead of steam up now, so we're rolling through this for you. Powers of trustees, woohoo. Most trust deeds will generally include a very broad empowering clause, such as the trustee shall have full power and authority to deal with the trust fund and generally manage and order the trust fund in all respects as if the trustees were the absolute beneficial owners of it. And that's, if you wanted to do a really succinct trust deed, technically that would do the trick, wouldn't it? Because there's no limitation there. I think the only thing trustees can't do that you can do is write a will. Anything else, the trustees can do it. So that would cover yourself. The problem we find in practice is that when a trust is dealing with a third party, such as a bank, they want to see some sort of specific power and get nervous just relying on general powers. So generally we will have a list, an extensive list of indicative powers included in a trust deed. And that's more a practical purpose. So this says that the trustees have got all the powers. So I like to call this the Ferrari clause. All right? So there's our Ferrari. And we know that a Ferrari 458, its official acceleration rate is 0 to 100 in 2.9 to 3 seconds. So what's the significance of this, you're thinking? What the hell is he doing? If you've got powers that a trustee can exercise, it's a bit like a Ferrari, isn't it? You know what you can do, but you wouldn't accelerate from 0 to 100 in 2.9 seconds out the front of a school zone, because you're going to have problems with the police and everything. So although you've got power to do it, you wouldn't necessarily do so. You would choose your discretion as to whether to put the foot down or not. And acting as a trustee and having those broad, unfettered powers is a bit like that. You can do as much as you want, but is it the right thing to do at the time? And so clients will often ask you, oh, we've got a power, we can do this. And you say, yes, technically you can. But from an underlying precept of trust principles, is it the right thing to do? And that's where a lot of people don't pick up on these things, and they'll give very black and white opinions saying, oh yes, there's a power under the trustee to do whatever the trustees want to do, therefore they can do it. The question is it the right thing to do in the circumstances? And that's where the discretion comes in, and how to act with a view to making sure that the trustees are on track. As I mentioned, indicative schedule of powers. Do your trustees that you use, do you have a long list of trustees' powers at the end? You know, a trustee, if you want, you can go pig farming on Waiheke Island or whatever and borrow money from a milk farming goat bank or whatever. You can do all those sorts of things because we like to preface that when we're dealing with third parties, and it just adds that bit more certainty. What does that bring us to? Trustee investment powers. It covers two aspects of the type of investments to be made and the duties owed by trustees when investing. This is not a major part of today because this is a standalone area, which Juliet covers in another part of the module. But before the Trustee Act, you may recall this Trustee Act Amendment Act, there are restrictions as to what trustees could do. It restricted the type of investments, when they could do them, and older trustees in some wills still have those issues. And that's one of the problems that we sometimes face, is that, and take for example the rest home or retirement village occupation licence. Although a trust would never own one of those, there are issues where under old trust deeds the old settlors are going into a retirement village, and sometimes you need to raise funds via the trust to pay for their occupation rights authority. If their trust deed is old, that it hasn't had the restrictions on investing lifted, they might not be able to do what they want to do. So it's a question of always looking back to your core document, especially older trust deeds, to see are there any legacy issues that we have to deal with. One of the problems you'll find in practice, especially if you're coming in after, say, 15 years of a trust having run, you'll have a look at the trust deed, you'll have a look at the financials and see what it says. Is it solvent? You don't want to really go into an insolvent trust. But what can happen over time is there can be incremental changes as to how the trust is run. And on their own, they don't really matter much. But if you look back to when the trust first started and then 15 years later, the change in tack can be quite significant and they're actually going off in a different direction. And whilst that's not a problem, provided the trust deed permits it, the question is the current activity within the scope of what's permitted by the trust deed? And that'll be particularly important if it's an older trust deed subject to the old investment rules. So it's always important to go back to the core document when you're working out what to do, especially when it's old.
Someone missed that one. The connection between the occupation licence and
Well,
investment.
in some cases, some retirement villages allow a trust to actually be included as the part, like a lender, and so the occupation licence will let them invest. The trust invest in it so they get paid back. The question is whether that would be permitted under the trust deed. In others, it might be that the trust has to lend money to the clients so that they can then buy their occupation licence. The question is an unsecured loan like that permitted by the trust deed under the old rules? So it's that sort of issue. This is actually a good point. The purpose of restricting trustee investment was to prevent speculation, as trustees ought to make prudent investments. That still hangs about. Although the trustees, we know from those general empowering clauses, can do anything an individual can do, there is still a cloud hanging over that you actually can't do aggressive or speculative investments because you've got duties to other people. You can do what you want with your own money, but the principles of trust law are that you shouldn't be making speculative or high-risk investments. And if that's the case, how do you manage that process where a client is adamant they want to go into a high-risk deal? And a high-risk deal might be a property development, for argument's sake. I think the strategy I would use for that is that form a company to carry out the activity. The client can be the director and the trust might have a shareholding in that company so that the risk is nominal. So it's a question of managing the risk and circumstances. We all know from the case of Selkirk, where his client was a property developer and he held himself out as being the independent sort of passive trustee. When the GST bill came through, the IRD pursued him and he went to court thinking he'd get a summary judgment saying that his co-trustee, who was the actual property developer, would just have to pay the GST. And the court said, actually, no, you can't separate your roles like that. You're jointly and severally liable. You are personally liable for the GST. So that's one of the questions. When you trust the client setting up a trust to do an activity, what is the activity? What is the risk associated with that? Is there a risk that you could become liable for it? If so, how best to deal with it? Separate yourself, interpose another intermediary to deal with it. Even if you own a house, as a trustee, you've got a personal and unlimited liability to the council for rates and things like that. If your client moves overseas and just keeps the property as a rental property and you're the trustee and they don't pay the rates, they're going to come after you because you have that liability and you can't limit your liability with the council. You can try, but they won't take it. So this is the new regime. Trustees may invest all the trust fund in any property that's permitted by the laws of New Zealand for the investment of the fund of trust or is otherwise permitted. But then you'll all know that we can contract out of those provisions. And most, if not all of your trust deeds will now contain an express clause setting out the contrary intention that those provisions don't apply. Because think about it this way, that if you have a trust that owns just the family home, you've not diversified your investment portfolio. Not only have you put all your assets into one class, but you put them all into one asset in the one class. So you need to contract out of those provisions. As I've just said, key aspect with the modifications relates to the diversification or non-diversification. Do you remember the famed case on diversification of the trust fund? Does that remind you? Mulligan and Pinegould Guinness? You all remember that case? Where Mrs. Mulligan was, she was a spinster, her husband died and left her a life interest in an estate, and the trustee said that we need to diversify this fund because the residual beneficiaries were grandchildren, and they said that we need to diversify the trust fund so that there's a gain in the capital value of the trust as well as just the income. The spinster, who was apparently quite a formidable woman and wasn't to be taken lightly, was saying that she had a chronic dislike for all sorts of investments and things, and she just liked getting the interest from the bank because at that stage interest rates were very high and she was doing very nicely. When she eventually died, she had developed quite a substantial portfolio of investments because she got great interest, plus she then diversified those investments herself and did quite well. And it was found that really they should have diversified the investment portfolio, and the hard decision for trustees in that case is, if you're not going to agree to diversify your investments, are we the right person to be your trustee? Because they should have been diversified. And they were kowtowing to one person. As strong-willed as she was, sometimes you have to make the ugly and the hard call. We are not the right person for you if you're not prepared to play by the rules. And I think that's a lesson for us, that it's all good until there are tears. We sometimes have to make those ugly decisions. And sometimes that's why we're brought in as independent trustees. I forget who mentioned it, but we get to help preserve the personal relationship between parties, in that it might be that a surviving mother might be under pressure from her children, or one of them, to distribute money to them so they can do something. And the mother might say to the child, I'm not sure. And they come to you as independent trustee and say, I really don't want to give him the money, but I don't want to say no to him. And in that case, you say, well, that's easy. What you do is you say that your co-trustee, who is the lawyer, will not agree to it. And that way you can blame the lawyer who wears the black hat and is hated by everybody, but it preserves the personal relationship. And the mother can say, I really wanted to give you the money, but the trustee won't let me. So that's a very practical version as to why the independent trustee can often work in family situations as well. I'm not going to bore you with some of the details of this case because we're trying to get out of here earlier. But I've just touched on that. She built up her personal investment portfolio to the risk of the others. I think the takeout point there, the damages awarded against the trustee company was $170,000. The amount of the estate in question was $108,000. So the costs exceeded what it would have been, because I think they got in from memory, had to get in actuaries to work out what it would have been worth had it been properly invested under modern portfolio theory, all that sort of stuff, and it would have been worth a lot more. And yeah, good reason not to be a trustee, actually. Trustee investment powers, you'll find there will be clauses. No trustee is liable for any breach of trust or for any loss in relation to the trustee's duties or investment, merely because the investments of the trust fund are not diversified. That's a contracting out type provision. You might want to put in your trust deeds to protect yourselves. Or the trustee shall not be under any obligation to diversify the investments in the trust fund. So in that context, picture it that the mum and dad say, okay, I know you're meant to diversify your investments. All I want you to do is the trust to own the family home. So if you put a clause in the trust deed that the settlors direct the trustees to invest solely in this particular property, you cannot then be accused of not diversifying the trust fund, because you have a parameter of instruction given by the settlors to say, this is what I want you to do. You might have a clause that said the trustees can elect to diversify from there if they see fit. But if they're complying with the original intention of why the trust was set up, it's difficult to see how you can be held accountable for not diversifying your investments from there. Any of you guys use protectors in your trusts? It's predominantly a feature of the offshore world, which has crept in a little bit to domestic practice. But it's essentially in the offshore world where you had clients, let's say clients in New York who were setting up an offshore trust and placing all the assets in the entitled into an offshore trustee, say in the BVI, The client might not feel entirely comfortable about that because they don't know who the BVI trustees are, and they might want to say that the trustees can act, but their protector has to approve certain transactions, and the protector might have been their lawyer. So the trustees, before they can act, have to seek the consent of the lawyer to certain things. Not a common feature, although it gets interchanged with different terminology in the domestic market. It might be called the appointor, and it's confused a bit where perhaps the appointors are given the power to appoint and remove trustees. It all depends on how the clause is defined in the trust deed, but the protector per se is not a feature of the common trust and not necessary in New Zealand, because in most cases the clients can also be trustees. It's usually when they're not as trustees that they want to have a safety mechanism in place as well. There are questions as to whether the protector is a fiduciary role or not, and again that changes under the FATCA rules. They're trying to say that a protector falls within their gamut of operation because they've got control or involvement with the trust, and obviously a protector doesn't want to be tarred with the brush of having fiduciary duties, the way they do things. It's a pretty grey area as well, but not something that we see regularly in the New Zealand domestic market. What we do see more of, and we touched on this before, is perhaps the advisory trustee. The other of you familiar with that concept? The advisory trustee is a little creature of statute here, which it says that the main trustees either have to or should consult with an advisory trustee. The advisory trustee has no title to assets and has no role, they have no control, but they're there as a consultative basis and can be a good mechanism to use for succession planning for bringing in children, in that they get information and they can give their input, but nothing they say is binding on the other trustees. So, that might be something that we see more often as the practice of trust law changes over time. You'll see here, this is the sort of clause you might see, that the trustees may consult the advisory trustee. Under the Act, it says the advisory trustee may advise the trustees, but does not become a trustee in respect of the trust. So they're sort of having their cake and eating it too, but it doesn't have the full power of being a trustee. And then it says the important part there, the trustee may follow the advice of the advisory trustee and may act on advice. And if the main trustees act on the advice of the advisory trustee, the main trustee is not liable for anything for reason of having followed their advice. But the advisory trustee is not liable. It's all a bit circular and a bit touchy-feely, but it can be a useful mechanism in certain circumstances. What might also become more prevalent is the custodian managing trustee structure. Often this is just seen in the institutional banking situation where the bank is the custodian trustee, they hold title to all assets and they invest everything, and there might be an investment advisor which is the managing trustee, which gives them directions as to what to do. And in that case, the role of the custodian trustee is simply to act in accordance with the directions of the managing trustee. But if you roll that down into a domestic trust situation, picture that you are the independent trustee, you are the custodian trustee, so your job is to hold title to the trust assets and to act in accordance with the directions of the managing trustees. Perhaps the clients are the managing trustees, so their name doesn't appear on title anywhere, so there gets that anonymity aspect to them. They get absolute control to decide between themselves what they want to do, and they then give directions to the custodian trustee. That's something that we might see more of over time. It's a fairly untapped area, and as I said, mainly used for institutional and banking type arrangements, but I can foresee that this sort of arrangement could follow through as people want more anonymity but to maintain their control, because you can see it gives you the best of both worlds, and it also protects the independent trustee because their job is solely to act in accordance with the directions of the managing trustee. Of course, they'll be caught up in litigation when any issues arise because title's in their name, and that'll become a little bit complex, but again, another mechanism that could become useful.
Could the custodian still have a fiduciary obligations?
Well, I think it's limited. Their fiduciary obligation is to act in accordance with the directions of the managing trustees. And the managing trustees have the major fiduciary duties as to how those funds are applied for the benefit of the trustees, of the beneficiaries.
How would you see that described in the trustee?
It
Appointed.
would specify that in accordance with Section 50 of the Trustee Act, the managing trustees are X and the custodian trustee is Y, and these are the specific duties. You take them out of the Act, put them into your trustee.
Could you get, sorry, I'm a bit unfamiliar with this. Could you give me an example of a situation where?
Yep, let's say you've got, you're acting for Doug Myers, one of his children who's receiving a significant inheritance under his father's estate, but he doesn't want his name to be entitled to all the documents. He wants to fly under the radar and be anonymous. So he might appoint Kensington Swan's trustee company to be the custodian trustee. So title to all assets will vest in Kensington Swan Custodian Trustee Limited.
Yeah.
He will be the managing trustee and he will tell you what to do. He'll say, okay, I want you to invest the money in this and this and this and this. Or he might say, I want you to pay out this much to such and such, or such and such. And your job is to comply with those directions unless you think they are in breach of the general principles of the trust.
So there's a main benefit for confidentiality.
I think there's absolutely confidentiality. And in a way, depending how courts interpret it, I think it would limit professional trustees' liability because their role is limited to complying with the directions of the managing trustee. The question would be in terms of creditor protection and perhaps even PRA issues, how would the courts interpret that under Clayton type situations where you've got two people who are still controlling the trust as trustees and somebody else merely has to act in accordance with their directions? Would that be robust enough for these purposes? As I said, it's generally for institutional banking and investment type arrangements where that works. On the domestic front, I think there's water to flow under the bridge to see what the implications would be. But again, it's something just to be wary of. Another issue, I think, is the settlor or reserved powers. In certain offshore jurisdictions, they will specify in their statutes that the settlor can have certain powers, in effect almost run the trust, and it won't compromise the trust's effectiveness or robustness. And that might be the power to appoint and remove trustees, the power to appoint and remove beneficiaries, consent to certain or veto trustees' decisions. That brings us back, though, to Clayton and Clayton. And we've seen how that has come back to haunt them in that case, that the reservation of certain powers to the settlor has been construed as tantamount to property, the property of which has a value equivalent to trust assets, and therefore opens up the door for property relationship claims.
Is this really fettering the trustees' powers?
Well, I think it comes back to the question of, is it actually a trust that you're trying to create? If the settlor has got, in effect, control over what happens, they've got a power of veto over everything, you're right, the trustees haven't got an unfettered discretion to deal with things as they think fit, but they're subject to the veto or whatever of the settlor. And so I think that really does bring into question whether or not a valid trust does exist. And has there been a sufficient divesting of powers and control to support and maintain the integrity of the trust? And I think that's something in the Clayton case that just wasn't really thought about. I'm picking that the commercial lawyer would have just used a trust deed, pulled it back, given some powers or more powers than usual to Mr. Clayton, the settlor, without realising that he's probably bastardised the trust deed to such an extent that it's changed its nature now. And as we know, it's caused an exchange of powers and property rights. So sometimes giving your client what they want is not always in their best interests. Again, that's sometimes the hard decision. If your client is adamant they want something, you've got to make sure you get a darn good disclosure of that, or an indemnity that they record they're acting contrary to your advice, they've instructed you to do it this way. That would certainly be the way to go these days.
Clayton reserved power was deemed to be property under the PRA, and the value was to the value of the trust. Has there been any cases where creditors argued that?
No, not yet.
property-
Not yet. It's just a question of wait and see.
Yeah, I mean,
It's a very logical step to take
makes
for a
no
creditor.
difference to me.
Absolutely. Only a question of time.
Even if it's just an argument you run to force a settlement.
Absolutely. It's only a question of time. Because if you take those principles out, even out of the family relationship context, and put them into a creditor situation, you'll say, well, look, the trust, in this case, the Supreme Court said this, this, this and this, therefore what's the difference that applies, therefore the value has to be such and such. So, absolutely. Absolutely, I agree. Trustees' liabilities and indemnities. Limitation of liability clause, and I presume all your trustees will have some form of limitation of liability clause in them, but they have limited effect because they're really only in the context of with beneficiaries. The main liability you're going to have as a trustee is with a contracting third party, and it's usually with banks, and it's often under guarantees or things like that, or with a property deal that goes bad, and perhaps if the sale defaults or falls over something, whether the trustees then get caught up. Now, although often a tangent, property transaction trustees, when you enter into a contract as a trustee vendor under the standard REINZ Southern Purchase Agreements, have you checked the limitation of liability clause? Do you ever change it?
Sale of purchase
Mm.
agreement. Yep. I mean, if it's not there, I mean, generally I have to put it in, but I can't
And
remember if it's there or
because
not.
there's now a standard clause in there. And I think from memory it says that the trustee's liability is limited to the value of the assets of the trust. How dangerous is that? It's not saying it's limited to the assets of the trust, so they can sue you to the value of the assets of the trust, and you then have to exercise your right of indemnity against the trust to get the reimbursement. So if you take nothing away from today, if you are signing a contract, or a client as an independent trustee is signing a contract for the sale of a property, amend that standard clause in the sale and purchase agreement to record that the liability is limited to the assets of the trust. Just strike out the little phrase, to the value of, because I think that's just a recipe for disaster as well. Even though it's a standard REINZ contract and approved with all the lawyers and things, shocker.
Is there an argument there as well, at what point the value is
Yes,
to be determined as well?
Yep.
Because, you know.
because values
depending
can
on-
change.
yeah,
Values can change
depending
dramatically
on-
when the cause of action arose,
Yeah.
and what happened. You know, if a claim is made at a certain date and it's worth $1 million, but all of a sudden when you go to exercise your right of indemnity, it's only worth $400,000. You're up the creek.
So like the assets of the trust at the date of.
Well, I just think if you put the assets of the trust, it doesn't matter what date it is, it's going to be what the assets of the trust are.
Yeah.
And in effect, all you do is say, okay, well, here, take the house. So if you take nothing else from today, get your little pen out and just rule through those 4 words. What are we up to here? Exoneration and indemnity. So the trustees have a right of indemnity against the trust assets to satisfy debts properly incurred in the administration of the trust. And I think we all know that as a matter of practice, that the trustees have a right of indemnity, and that's recognised both in common law and in statute. The trustee acts as a trustee may reimburse himself or pay or discharge out of the trust property all expenses reasonably incurred in or about the execution of the trust or powers. Doesn't say professional costs there. It says reimburse or discharge expenses reasonably incurred. So that wouldn't give you the right to charge your professional fees if you're acting as an independent trustee. So you need to make sure that your charging clause specifically covers what you're entitled to. And in that regard, I was involved in a case where there were questions as to whether the lawyer, trust or executor's standard rate of charge was applicable because that includes an element of profit. And, it's meant to cover all your costs and make a profit. And the barrister was saying, well, I think you're only entitled to a recoupment of your expenses, not for your normal charges. And I thought, interesting, but I now record in my charging clauses that they can be paid for their charges and expenses at their usual rate of charge plus GST and disbursements, just to cover that sort of aspect. Because I think we have to face it, none of us do this for love. We do it because we're in business to make money somehow. Let's not cut off our noses to spite our faces. We do enough of that with offering traditionally free trusteeships. So there are two aspects to the indemnity, where the trustees expend their own funds for trust expenses. They get a right to recoup that back from the trust. That makes sense. Yep. The right of exoneration is one which is probably more dear to our hearts, where the trustees pay trust liabilities directly out of the trust assets. That might be, for example, an executor paying the funeral account for some reason. Although I don't think very many of us these days write cheques out of our own pocket to meet client trust or estate expenses. We can normally find somebody else to carry that can for us. But you can do that. But if there's a client who's an executor and of a family's estate, they'll be inclined to pay it out, but they're entitled to have that repaid. So that's the sort of situation. The right of exoneration. The trustee shall be entitled to a full and complete indemnity from any and every part of the trust fund for any personal liability for the debts, engagements and liabilities of any business or partnership in which the trust fund has been employed, notwithstanding the whole of the trust fund may have been employed. That's the sort of clause you'll probably see in your trust deeds when you go back and have a look. That's the template, that's those old phrases that have come through. And the reason for that we now know is to make sure that trustees get not just their statutory right of reimbursement, but to be exonerated for their other costs as well. Now, the next clause, as I always know when clients have read my draft trust deed, is hot pot. Most of them think it's a hot pot and can't work out why there are recipes in the trust deed. But that's always a very good litmus test, because it's 2/3 of the way through. And you can tell at night time they're reading and glass of water, and then they get bored and turn off. Hot pot, always a good example. But the explanation I give to them is, imagine the trust that there's 3 children. You've got one of them who's a child prodigy, one of them who's a spendthrift, and one of them who's just a normal, plain old Jane type person. And the spendthrift is always having to be bailed out by the trust because they're always in trouble. The trustees might say, look, that's fine, but buddy, when it comes to the end, we're going to take into account the money you've already received, and that comes off your share at the end. So it's going to come into account, so it's being brought into hotspot. You don't get 2 bites of the cherry. The prodigy might have to go across to an American university where it's $100,000 US each year, and they become a leading cancer researcher. You think, well, that's a really good investment. We've spent $500,000 on them, but that was a really good investment. You can still share equally with what's left in the trust when it comes to an end, because we think that was a good lifestyle investment for the trust. And the other family member who just went through life, no significant issues, whatever, just gets their 1/3 share. It's invariably going to be for the problematic beneficiary who has had to get assistance all the way throughout, where you might need to bring that back so they don't get 2 bites of the cherry. And most parent trustees think, yeah, no, fair call. And you can always see the lights go on. When there are 3 children, there's always one in that category, and they think, yeah, actually it makes sense, understood. So again, it's keeping our options open, but understanding why it's there, so that, to give a client a good example as to what it does. An example of that clause, in the exercise of any of their powers and discretions conferred in clauses 6 and 7 regarding the trust capital and resettlement, but without any way restricting such powers, the trustees may, upon the transfer or resettlement of any part of the capital of the trust fund to or for the benefit of a discretionary beneficiary, direct in writing that the part transferred or resettled is to be taken into hotspot in ascertaining the share of that discretionary beneficiary. That's the sort of clause I'd imagine that you'll already see in your trust deed, something like that. but now hopefully you've got a bit of a better understanding as to what it means and why it's there. What's another example? A beneficiary on the vesting day and upon such direction, carrying on. So it's basically telling beneficiaries that they've got to bring into account that sometimes they won't get 2 bites of the cherry. So as you will sense, we're working our way through the trust deed. We started off with the intention, we've done capital and income, we've done a bit of other stuff, resettlement, we've done a bit of hodgepodge, we've done a bit of resettlement. We're now up to one of the interesting things which was touched on earlier, the variation or amendment of a trust deed. There is no standard provision in that regard. But it's interesting that there are some common law bases for this. In Hemming and Chambers, which I don't think was Justice Chambers, but it just happens to be familiar there, a general empowering clause intended to give the trustees the fullest possible powers could not be used to vary a trust deed. So you remember that clause back? We had the general empowering clause, the trustees can do anything they think fit as if they were the absolute owners. That was relied upon as a variation clause, and it was struck down because no, you couldn't do that. Right? In that case, the clause specifically said the trustees may do everything they think desirable, notwithstanding it's something which they would not normally have power to do in the absence of a court order. We come back to the dispositive or administrative aspects, and what's happened is there's a special carve-out of the administrative provisions here, that you can't use those administrative provisions generally for the variation. It's got to be a specific intentional clause to go in there. So even when there's specific wording, the power to vary or amend must be exercised for the purpose for which it was granted, and the power must not be exercised beyond the reasonable contemplation of the powers. This is all quite interesting stuff because it comes back to, remember the Ferrari clause, where it says on the face of it you've got power to do whatever you want, but actually can you do whatever you want? So there are 2 limbs to the variation. Does the intended variation fall within the purpose of the variation clause? If you recall our discussion before, the variation clause was generally intended to ensure that if there's a change to facts or circumstances or statute or case law that prevents the original intention of the trust being adhered to, you can vary the trust deed to ensure that purpose can be continued. That's what the variation clause is for. And is the intended variation consistent with what the parties would expect? There was a case a while ago, and I don't remember its name, but I think it was a trust owned a property in Ponsonby, and they wanted to sell the property, and there must have been some tax implications arising, and they thought that if they varied the trust deed to change the class of beneficiaries and put in the purchaser's family's beneficiaries and take out the vendor's family and vary the trust deed that way, they could change ownership without having any of the tax issues. But that ended up being struck down because it was not consistent with the purpose of the trust. If you think the purpose of the trust in that case was to protect and preserve assets for the benefit of that family, changing the family group is inconsistent with that. I don't know. I've thought of that as well. I wonder who bought that. But the question is, how would they have found out? Maybe it's an urban myth. Who knows? Who knows? Because I can't remember the case. Maybe it's urban myth. What's this say? If at any time the trustees decide that for business reasons it is appropriate to change any clause in this. This is an actual clause I've seen. If at any time the trustees decide that for business reasons it is appropriate to change any clause in this deed, they may do so, provided always that such changes do not have the effect of extending the perpetuity period. What are business reasons? And how limiting could that be? So sometimes if you try to be too clever and have a restrictive clause, it's going to bounce back to bite you. And the general provisions that have been tried and tested over time are usually the ones that work. this is similar to that case I was talking about, whether it's urban myth or not, but the variation clause cannot be used to change the fundamental provisions of the trust referred to as the substratum. Now, I think that question comes in, it is doubtful whether a power of variation can be used to add and remove beneficiaries, and I'd have to agree with that, because the power to add and remove beneficiaries is almost like a dispositive provision, whereas the power of variation is to deal with the administrative clauses. And that's always something to think about when you're being asked to see whether there's power to do something. But the substratum, the question, can you vary a trust deed to bring in more final beneficiaries, even if there's a power to add beneficiaries? Do you, in your drafting, say that the settlors have a power to add in more final beneficiaries or just discretionary beneficiaries? My concern is if the power is to add in further final beneficiaries, you may well be having problems because it's changing the substratum a bit, because if the trust was established for this family group and then you bring in, you think, oh, I want to add in just in case my cousin's children or something, you've changed it. And does that change, is that in the best or worst interests of the existing final beneficiaries? So if you exercise that power to add in a final beneficiary, I think you could have an argument that there's a breach of fiduciary duty to the existing final beneficiaries because you're bringing in more beneficiaries and therefore potentially watering down their interests. And it also, tying in with that, it changes the substratum, the underlying intentions of the trust. So checking even though you might have clauses to add beneficiaries, is it final beneficiaries or is it just beneficiaries? I'm always incredibly reluctant to permit the addition of further final beneficiaries unless there's a compelling reason or a mistake that's been made in the first place, that someone's been left out. But generally, if you form a trust for parents and the children, the final beneficiaries, it's pretty clear what they intend. And anything else is just an afterthought. And I think can be a dangerous exercise. Okay, so these are some more examples of trust variation clauses that you might see or use in your trust deeds. The trustees may, during the trust period, by deed modify, vary, revoke or enlarge all or any of the provisions of this deed. And then there's the proviso: no modification, variation, revocation or enlargement concerning the management and administration of this trust. So see how that's been restricted down to the management and administration. And I think that's probably the more technically correct provision, because we're dealing with the management and administration of the trust to make sure we can give effect to the intended dispositive provisions in the first place. So it's got the rider about not breaching the rule against perpetuities and remoteness of vesting, all those sorts of things. But I think the fact that it's drawn out that distinction about the management and administration is the correct way that the clauses should read. And if they don't read that, and it's just like the general first part, any modification of this trust deed, I think as trust lawyers we should probably think, actually, it really is limited by way of general principles just to the administrative and management provisions that we can vary, and we really can't change the dispositive provisions, because to do so is then looking to change the substratum. Guess what?
It's not that we didn't like you lecturing.
I know, it's Sunday afternoon. Oh, look, I've rushed through that. But does it give rise to any questions? One of the questions I also often get asked from clients is the ability to change trustees. And so I always point out that I think it's crucial that the clients have the power to appoint and remove trustees, because I've got to highlight that doesn't control the trust, but they can control who controls the trust, because it's the trustees acting jointly who control the trust, right? So and that comes back to our Clayton issues and to our bundle of rights and things like that. No one trustee has a right to control the trust. It's all trustees acting jointly. But if the clients have the power to decide who those trustees will be, that's how they control the trust. So that is, in effect, the most critical aspect to a client in setting up a trust, and that's where they exercise their control. And so there are all sorts of ways of structuring those powers. Some people do it that each set law has the power to appoint a trustee and remove a trustee. I find that all cumbersome and confusing. I do it that for a couple, the husband and a wife have the power jointly, while they are both living in sui juris, which is the same thing, living incompetent, to exercise that power to appoint and remove trustees, so that one of them can't run off to the lawyer and say, had a big fight last night, want him out, get rid of him. So that covers that problem, and it means that it's just the independent trustee who can be changed. And they say, oh, that's good. So if the trustee doesn't do what we want to do, we can just change trustees. And I'll say, yes, you can, but remember your Ferrari, the Ferrari clause. So you've got power to do it on the face of it. So let's take the extreme example that you think, oh, look, I've had a premonition and 8 black up at the casino is going to come up and we're going to take out a loan of 500 grand to put it up on the roulette table. And your independent trustee says, no, I don't think it's a good idea. And so you sack that independent trustee and bring in the next independent trustee who says, no, I don't think it's a good idea. And you do that 3 or 4 times until you finally find a trustee who goes, oh, yep, that's a great idea. I think that the way you've exercised your power has compromised the integrity of the trust. Although you had power to do it, the way in which you've done it has been your unfolding. And that's one of the questions I often get from clients. How and when can that power be exercised and to what extent? It's a bit like property sales, isn't it? That it's hard to tell with the IRD, can you do 1 property a year or 2 properties a year or 3 properties a year before your quarters of property traded and having to pay tax on that? How many change of trustees can you do before it starts to become dodgy? The facts will speak for themselves.
So it strengthens the trust when there's on record a decision against.
Absolutely. Sometimes the resolution not to do something can really provide some steel and backbone for the trust. Absolutely. So is there anything else?